So we'll start now right away with the first key session after the wonderful address by Professor Nafziger, a session entitled National Treasures and Common Market. So after Professor Nafziger's presentation, I see the issue with having national treasures in the title and the problem with defining this. We're going to have two speakers instead of three, so a little bit of a shorter session to accommodate one of the speakers' arrival time. We're first going to hear from Maciej Górka. Apologies for my pronunciation if it's not quite correct. Who is coming from the European Commission in Brussels. Delighted to have him as a presenter today because he's absolutely the right person to present to us today the Directive 2014-60 on the return of cultural objects, as he's heading the unit who is managing the directive. A very important address, as we will then have presentation later today and tomorrow on how member states are implementing this directive. We will then hear from Marina Schneider, who, if you prefer, you can come later or sit with us. Sit with us at the panel. Marina Schneider is a senior legal officer at UNIDRA in Rome, and she will be presenting in further detail one of the three legs of the tripod presented by Professor Nafziger, the 1995 UNIDRA Convention. And again, we're very pleased to have her because she is the key person to discuss this convention. She's been involved with it since the very beginning and is now still overseeing its implementation. So first, I'll leave the floor over to Maciej Górka.
Thank you very much. Good afternoon to everyone. First of all, I'd like to congratulate the organizers on the coming up with this initiative to have this conference. Thank you very much for inviting a representative from the European Commission. I'm very glad, and it's an honor to be here among other distinguished guests, participants and speakers. So, well, starting with the directive, as this is the primary topic of the conference, it's maybe important to say as a starting point that the Directive 2014 is a recast of an old directive dating back 93, and the initial directive was adopted at the moment when the common market or internal market was established. So when the idea was to abolish the frontiers among the member states, and as a complementary measure, it was supposed to give a guarantee to the member states that those objects which belong to heritage and are among the national treasures, if they are unlawfully removed from their territory, they could be returned. So that the procedure exists which the member states can use on the occasion when these national treasure items are removed from their territory unlawfully. Is it? No. How does it? All right. Thank you. So the directive aimed at reconciling the fundamental principle of free movement of goods with the need for effective protection of national treasures. As mentioned just a while ago, there is this derogation provision in the treaty which allows the member states to prevent the circulation of goods which belong to this category of national treasures, even though the goods are supposed to circulate freely. And my presentation here will cover these three basic points: the circumstances leading to the adoption of Directive 2014/60 in May 2014. Then I will say a few words on how the proposal for a recast directive was prepared in the Commission, what the Commission intended to put in it, and why at all it came up with this initiative. And then shortly this presentation will also cover the steps for the implementation of the directive and the state of play of the transposition by the Member States. So, as I said, in '93 the initial directive was adopted and transposed into the national laws of the Member States. And according to the directive, every 3 years the Commission was supposed to prepare the report on the application of the directive. So the role of the Commission was to review to what extent Directive 93 and /7 is used, and whether there is any need for amendments or for improvements. And indeed, in 2009, it was concluded in the report that the Commission should engage together with the central authorities in charge of the directive in a reflection on a possible revision of the directive. And this reflection was carried out within the working group of representatives of the Member States, of the central authorities, within the Committee on the Export and Return of Cultural Goods. And the conclusion was, in 2011, that indeed the directive should be revised to make it a more effective instrument for the return of national treasures. I will say a few words on the reasons why such conclusion was drawn. Basically, the directive, as it was conceived initially, it was covering the national treasures, but it established certain conditions under which the removal of these national treasure items could have been claimed under the directive. And those conditions were set out in the annex to the directive, which established certain criteria, like categories within which these items should fall in, or the thresholds, like financial or age threshold. So in practice, even though there might have been some items which qualified as national treasures, but in case of their unlawful removal, the procedure established by the directive and implemented by the Member States couldn't be applied, simply because these were not categories as set in the annex to the directive, or these other conditions were not met, like financial or age thresholds. So the scope, basically the scope of the directive was not considered satisfactory, or there might have been some improvement. The second thing was short time limit for bringing return proceedings, because the directive decided back then in '93 that the proceedings could be started within 1 year from the moment the Member States becomes aware about the location of the item or the identity of the possessor. So this time limit of 1 year was considered also to be too short. And then finally, there was a question of compensation to be paid, and sometimes it was considered that the costs that the Member States must consider for claiming the item was too high, and the Member States were giving up on claiming the object back to their country simply because of the high costs involved. And the evaluations also highlighted that there is a need for improved administrative cooperation. These are practical things like question of the language in which the member states' authorities could communicate with each other, which authorities should be involved, and so this kind of facilitation, which might improve the overall process, was also taken into account here. So as a result, there was a public consultation launched in November 2011. The public authorities, citizens and economic operators. And the outcome of this consultation was basically that the public authorities took the view that the directive did not guarantee the return of national treasures unlawfully removed from their territory, whereas private sector was rather of the view that the directive was satisfactory. However, when we looked into the detail of this consultation, it was considered that this conclusion from the private sector was not really representative. There was a kind of, there wasn't full representation in those who were taking part on in the consultation from the private sector. And the Commission proceeded with the impact assessment of the revision of the directive, and there were a few options taken into account. One, that there would be no change to the current situation, so the Directive 93/7 would continue. These amendments, which you could see here, which you can see here, directives from 93 and 2001, they were mostly dealing with the annex. So they were amending the annex to the directive, changing a bit the categories, or were linked to the euro as a currency in the European Union because of the financial thresholds which were there. The second option was kind of a soft instrument, like promoting the use of common tools by the central authorities. And it was considered to allow the use of the internal market information system, which is basically a system functioning among the member states' authorities, which allow for easy contact between the authorities participating in the system. Second option was the revision of the directive, so going for the legislative process and proposing a few changes, like extending the scope of the directive, extending the time limits, and aligning the conditions for compensating the possessor in view especially of these problems with the high costs of the related to the return of the object. And fourth option, encouraging ratification and application by the member states of the UNESCO Convention of 1970 on cultural property. There were other options discarded, however, right away at the beginning of the process, so even not put into the impact assessment, like ratification by the European Union of the UNESCO Convention and UNIDROIT Convention, adopting a strategy by the EU to encourage all member states to ratify and apply the UNIDROIT Convention, replacing Directive 93 with a regulation. As you know, there is more and more approach in the European Union that regulations are considered to be more effective because they allow for direct applicability of the provisions of the legal act, whereas directive must be implemented, transposed first and implemented on the basis of the national rules, and repealing Directive 93. But these four, as I said, they were abandoned at the initial stages. Either it was considered that they are not realistic, or not feasible, or not effective. So, so the preferred approach out of these four options that I have mentioned, it was a combination of option 2, which was this IMI system, the system of cooperation between the administrations of the member states, and the revision of the directive. And in 2013, in May, the Commission presented a proposal, and the most important changes were the extension of the scope of the directive to cover all cultural objects, classified or defined as those among national treasures within the meaning of Article 36 of the treaty, which was the result of it was the deletion of the annex, so that there are no categories and no thresholds. Whichever object is defined or classified by the national law in the member states as national treasure, it may benefit from the directive. The compulsory use of the IMI system, so the establishment of the IMI system customized for the return of cultural objects becomes a part of the directive, and is a mandatory tool to be used by the member states in their exchanges concerning the return of cultural objects. The proposal also provided for the extension to 5 months from 2 of the time limit given to the authorities of the requesting member state to check the nature of the cultural objects, which is basically to verify by the requesting member states that the object found in the territory of another member state is indeed a national treasure, a cultural object in the sense of the directive. The proposal from the Commission was 5 months. As we will shortly see, it was finally decided to set it at the it is 6 months now. And the extension to 3 years from 1 year of the time limit for bringing return proceedings. Also, the directive, the proposal included the identification of the central authority as the one which is responsible in a way for taking steps in case it becomes aware of the location of the cultural object and the identification of the possessor. Another novelty which the proposal from the Commission was the uniformization of the burden of proof of due care and attention in acquiring the cultural object. In the proposal, it was decided that it should be the burden of proof should lie with the possessor. Until then, in the directive, in the initial directive of '93, it was left to the member states' legislation to decide how to prove that the due care and attention is exercised when acquiring an object. The proposal also referred to the criteria for interpreting whether the due care and attention was exercised, and those are inspired by the UNIDROIT Convention included in Article, if I remember correctly, Article 4 and Article 6, as you can correct me if I'm wrong. So the directive takes over the concept of due care and attention. And eventually, also the proposal from the Commission proposed the extension to 5 years, the period for the presentation of national reports from the Member States and the report reviewing the application of the directive. So, as I said, in May 2013, the proposal was put on the table, and the negotiations went quite fast, and the proposal got much support during the legislative procedure in the European Parliament and in the Council. Eventually, there have been only a few changes, and not in the essence of the Commission's proposal. The European Parliament suggested introducing a reference to the Council conclusions of December 2011, inviting Member States to ratify the conventions of UNESCO and UNIDROIT. Whereas the Council suggested to insert in the recital that the Commission should set up an expert group composed of central authorities which will be involved in the implementation of the directive. Just my comment on this. Until then, within the framework of the directive, there was a committee working and established under the regulation on the export of cultural goods. And this committee was also working on behalf, within the framework of this directive, and was mostly involved in amending the annex, as we gave up on the annex. The annex was not supposed to be anymore the part of the directive. Also the committee, there was no reason for the committee to continue. But the Member States authorities participating in the negotiations, they insisted that there is some form of involvement on the part of the experts from the central authorities, and this took form of an expert group. So eventually, on 15 May 2014, the European Parliament and the Council adopted the directive. And I would say that the fundamental difference with the old one is indeed the scope of the directive. And it covers all cultural objects identified as national treasures possessing artistic, historic or archaeological value under national legislation. It should be mentioned that also already in the initial directive there was a reference to the mutual recognition. So the initial directive, even though it established the annex with categories and thresholds, in the recital it was saying it is just the first step in this field, and as an ultimate purpose there should be a mutual recognition among the member states on how they define or classify their national treasures. So with the trust, there should be a trust among the member states that they wouldn't be going beyond what they indeed consider as national treasure. But the concept, as we have heard just a moment ago, indeed is hardly defined on the international level. So this is why we need to rely on what the member states consider as their national treasure. Then there is a provision on the internal market information system as a tool to be used by the member states when consulting each other or exchanging the information on the cultural objects found on their territory and verifying whether these are indeed objects unlawfully removed from the territory of another member state. Again, new directive confirms this new time limit of 3 years for initiating the proceedings before the national court in the requested member state. So the procedure is that after confirming through the IMI that indeed this is an object sought by a member state and it was unlawfully removed, the member state which is requesting an object goes to the national court in the requested member state where the object was found, and there tries to secure the return, the physical return to their territory. In view of diminishing the costs related to the return, the person acquiring the object will be entitled to compensation provided that he or she can prove that they exercise due care and attention in acquiring the object. Also, these non-exhaustive criteria, they may be supplemented by other criteria which the court should take into account when assessing whether the compensation should be paid. The directive refers to a fair compensation in view of circumstances. And again, this 5-year period for preparing the reports by the member states and by the Commission on the application. Immediately after the adoption of the directive, an expert group on the return of cultural objects was established and was until now mostly involved in elaborating this IMI system customized for the return of cultural objects. Within the framework, some of participants here also are members of this expert group, so I won't be explaining too much, but we were trying to work out how the forms to be used in the IMI system. For those who are not familiar, there is an IMI regulation recently amended in 2012, if I remember well. The regulation 1024/2012, so from 2012, which established the cooperation, administrative cooperation under the umbrella of IMI, and it is used in such areas like Services Directive or the professional qualifications or posting of workers, or there might be one or two other areas where this IMI system is used. And also since 19 December, so the date of the deadline for the transposition of the directive on cultural objects, it should also be used for this purpose. So it covers the questions in all languages which the member states could ask each other as concerns the situations which may involve the removal of the cultural objects from their territory, for verifying the description of the object, etc. So all these categories, for the purpose of the IMI, the annex, which is not there anymore, but was useful. Agreed on the forms, scenarios, and set of questions, answers to be in the IMI module. The expert group has met 3 times, and the next meeting is planned for 12th April in Brussels. The member states now are appointing, either have already appointed competent authorities for IMI purposes, and also the coordinator, someone who will play a role of the coordinator for the module. So any questions that arrive to the member states do not stay unanswered. And there is immediately someone involved in preparing the replies whenever such a request arrives. The directive, well, this information is missing here, but the directive was supposed to be transposed to the national law of the member states by 19 December last year. So, well, the timing of this conference is very good, because now we have already received some communications from the member states, but as you can see, not from all. Until now, I mean, the information is verified 2 days ago, well, before the weekend, and there are 19 communications, so 9 member states are still working on their transposition of the directive. Already in January, and this is something which happens pretty much automatically in case of non-communication of the transposition, that the Commission proceeds immediately to launching the infringement procedure. It is different a bit, the procedure, internal procedure in the Commission is different from incorrect transposition or for non-application. But in terms of the new directive and the fact whether or not the member states communicated the transposing measures, these proceedings start pretty much automatically. And in January it was launched against 16 member states, and by now, and between January and now, 7 communicated the measures, whereas for the others, the Commission will continue the proceedings, which the next step is the reasoned opinion. And as you may know, in case of infringements for non-communication, the Commission may immediately, at this very early stage, specify a lump sum or penalty payment to be paid by the member states who haven't communicated their measures. But hopefully it won't be necessary, because basically, and this would be the conclusion of my presentation, this directive, of course, is in member states' interest, because it, and this was something which wasn't always realized by those involved in the negotiations or the discussions, that by removing the annex, it extends the scope of the objects which can be returned or which can benefit from this procedure. Because of course there might be other procedures involved in the return, but this should facilitate whenever there is a situation which where the objects was removed unlawfully, the member states should have an opportunity to use this through the directive means. And I guess I exhausted the time, so I'd like to stop here at this moment. Thank you very much for the attention.